नमस्ते, सदा खुश रहो बिटिया. I, Jv'n Dr L Sharma, Professor Jyoti Vidyapeeth, Women's University, Jaipur. Today our topic is High Courts. Chapter 5th of the Constitution of India deals with the High Courts in the states. Article 214 to Article 231. There are 25 High Courts in India. The Calcutta High Court, established in 1862, is the oldest High Court in India. The Mumbai and Madras High Courts were also established in the same year. The newest High Court are the Telangana Court and Andhra Pradesh High Court, both established in the year 2019. The Mumbai, Madras and Calcutta High Courts are the three chartered High Courts in India. The Madras Law Journal, published from Madras High Court, was the first journal in India dedicated to reporting judgments of a court. 1891. Article 214. There shall be a High Court for each state. High Court to be a court of records. Article 215. Every High Court shall be a court of records and shall have all the powers of such a court, including the power to punish for contempt of itself. Constitutions of High Courts. Article 216. Every High Court shall consist of a Chief Justice and other judges, as the President may from time to time deem it necessary to appoint. Appointment and condition of office of the judges of the High Court. Every judge of the High Court shall be appointed by the President by warrant under his hand and seal after consultation with the Chief Justice of India, the Governor of State, and in the case of appointment of judges other than the Chief Justice of High Court and or acting judge, as provided in Article 224, or in any other case until he attains the age of 62 years. Application of certain provision relating to the Supreme Courts to High Courts. Article 218. The provisions of clauses 4 and 5 of Article 124 shall apply in relation to a High Court as they apply in relation to the Supreme Court, with the substitution of references to the High Courts for the references of the Supreme Court. Oath or affirmation by the judges of High Court. It comes under Article 219. Every person appointed to be a judge of High Court shall before the enter upon his office make and subscribe before the governor of the state or same person appointed in that behalf by him. Restrictions on practice after being a permanent judge. Article 220 states that no person who after commencement of this constitution was held office as a permanent judge of High Court shall plead or act in any court or before any authority in India except the Supreme Court or other High Courts. Salaries and other emoluments of the judges. Article 221 deals with this thing. There shall be paid to the judges of each High Court such salary as may be determined by the Parliament by law. Transfer of judges from one court to the another court. Article 222 states that the President may, after consultation with the Chief Justice of India, transfer judges from one court to any other High Court. Appointment of acting Chief Justice. Article 223 deals with this. When the office of the Chief Justice of High Court is vacant and when any such Chief Justice is by reason or absence or otherwise unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purpose. Powers of the High Courts. Jurisdiction of the existing High Courts. Article 225 deals with this procedure, in which it states that subject to the provision of this Constitution and to the provisions of any law of the appropriate legislature made by the virtue of the power conferred on that legislature by this Constitution, the jurisdiction of and the law administered in any existing High Court and the respective powers of the judges thereof in relation to the administration of justice in the court, including any power to make rule of court and to regulate the sittings of the court and of the members thereof sitting alone in division court, shall be the same as immediately before the commencement of this Constitution. provided that any restrictions to which the exercise of original jurisdiction by any of the high courts with respect to any matter concerning the revenue or the concerning any act ordered or done in the collection thereof was subjected immediately before the commencement of this constitution shall no longer apply to exercise of such jurisdiction. Power of high courts to issue a certain writs. Article 226 deals with this. Notwithstanding anything in Article 32, every high court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government within those territories discretion, orders or writs, including habeas corpus, mandamus, prohibition, quo warranto, etc., or any of them for the enforcement of any rights confirmed by the part third and for any other purpose. Power of superintendence overall courts by high courts. Article 227 states that every high court shall have a superintendence over all courts and tribunals throughout the territory in relation to which it exercises jurisdiction. Without prejudice to generality of foreign provisions, the High Court may call for returns from such courts, make and issue general rules and prescribe e-form for regulating the practice and proceedings of such courts, prescribed forms in which books, entries and accounts shall be kept by the officers on any such record. The High Court may settle these tables of fees to be allowed to sheriff and all clerks and officers of such courts and attorneys, advocates and pleaders practice therein, provided that any rules made from and prescribed or tables settled under clause 2 or clause 3 shall not be inconsistent with the provision of any law for time being in force shall require the previous approval of the governor. Fourth, nothing in this article shall be deemed to confirm High Court powers of the superintendence over any court or tribunal constituted by or under any law relating to the armed forces. Transfers of certain cases to the High Courts. If a High Court is satisfied that a case pending in our court subordinate to it involves a subsequent questions of law as to interpretation of this constitution, the determination of which is necessary for the disposal of these cases. Officers and servants and expenses of High Courts. The appointment of officers and servants of High Court shall be made by the Chief Justice of the court or such other judge or officer of the court as he may direct, which it comes under the category of Article 229. Extension of jurisdiction of High Courts to Union Territory. Article 230 deals with Parliament may by law extend the jurisdiction of High Court to or exclude the jurisdiction of High Court from any Union Territory. Second, when the High Courts or state exercise jurisdiction in relation to the Union Territory, A. Nothing in this constitution shall be constructed as empowering the legislature of the state to increase, restrict or abolish that jurisdiction. And B. The reference in the Article 227 to governor shall in relation to any rules, forms or tables for subordinate courts in that territory to be constructed as a reference to the President. Establishment of a common high court for 2 or more states. The Article 231 1. Notwithstanding anything contained in the proceedings provisions of the chapter, Parliament may be by law establish a common high court for 2 or more states or for 2 or more states and union territories. In relation to any such high court, A. The reference in the Article 217 to the governor of the state shall be constructed as a reference to the governor of all the state in relation to which the High Court exercises jurisdiction. The reference in the Article 227, the governor shall in relation to any rules, forms or tables for subordinate courts be construed as a reference to the governor of the state in which the subordinate courts are situated. The references in the Article 219 and 229 to the state shall be constructed as a reference to the state in which the High Court has its principal seat, provided that if a principal seat is in a union territory, the references in the Article 219 and 229 to the governor, the Public Service Commission, legislature and the consolidated fund of the state shall be construed respectively as a reference to the President, UPSC, Parliament and consolidated fund of India. This is all about the high courts in India. If you're facing any problem, then write a comment in comment box which can be solved in live session. Thank you.